go on the record now in People versus Kevin Whitefoot, case number 245364. Mr. Whitefoot, come to the podium there, please.
Oh, geez.
Sierra Coke on behalf of the people.
All right, this is the date and time set for sentencing hearing in this matter. Mr. Whitefoot, did you have a chance to go through the pre-sentence report and talk to Mr. Gerber about that?
No, I didn't go through any pre-sentencing today at all, no.
We've gone over it previously, Judge.
Did you go over it with him before?
I'm assuming we're talking about that one phone call we had.
Well, we went over the pre-sentence report, we discussed sentencing.
Mhm.
Yes, that's what Judge is asking. You remember
Oh.
having the conversation?
Yeah, if we did, if we handle business on the phone, correct, yes, that is true.
Do you need some time to go through that with him here today?
You wanna go through that just one more time to make sure that we're both on the same page?
I don't have to. Do you need to?
Yeah,
It's a
I would
question
prefer
for
we
you.
do,
Okay.
yeah.
Okay, all right, I'll give you a couple minutes to do that.
I know Mr. Marvin's attorney is not here, and Ms. Shifflet should be apparently from Sheboygan County, so she's on. But that's
Right.
on.
All right, we'll come back in the record about 10 minutes.
And you don't see Sheboygan yet, Judge.
Okay, we're back on the record. Mr. Whitefoot, did you have a chance to go through that report again with Mr. Murphy?
Yeah, it's where I have absolute better understanding, and a refresher is always good.
Okay. Mr. Murphy, are there any additional deletions or corrections to that report?
No, just that.
Just the scoring of the guidelines.
No.
Ms. Coe, if people have any additions, deletions, or corrections?
No, Your Honor.
One question I had, just because it seems like a high amount here, the restitution requested is in the report is $40,000.
It was the ATM was broken at the bank, and they actually, I don't know if they've replaced it, but it's not there anymore. So that's just the number that they sent to us.
Did they provide you any kind of documentation?
Let me check. They gave us the $5,000 for the cleanup, $10,000 for the rigging, $19,000 for the replacement, and $6,000 for the gate replacement.
Okay.
So-
All right. Because Mr. Whitefoot didn't actually get any of the cash, right? He didn't-
No, they didn't. Stretch.
No.
No, he didn't break into get the cash.
Attempted
Attempted to get to the cash.
Attempted very hard with tools.
Yeah, okay. I'm gonna attach this receipt and restitution report as part of the PSI. I just want to make sure that there was some documentary justification for the amount. Ms. Koch, do you have any objections to the guidelines as scored?
No,
Do you have any victims that wish to address the court today?
they did not.
Anything by way of allocution of behalf?
Of course, aware of what happened. I mean, Mr. Whitefoot clearly was trying to break into the ATM. He made the admissions early that he did it, and the recommendation here is 12 months in jail. Whether or not, I debated whether or not to ask for the 13 months or 14 months for prison. But he doesn't really have a very lengthy criminal history. So I'm not really sure what made him think this was a good idea. This is someone who's only 30 years old with only 2 misdemeanors. It seems kind of bizarre behavior. I understand that he has some mental health issues that he is addressing or needs to address. So I'd ask the court to follow the recommendation.
Thank you, Mr. Murphy.
Judge, just by way of some background, so the record is clear, Mr. Whitefoot pled at the initial arraignment. I think Mr. Trush was the arraignment attorney and advised him to plead not guilty. Wait till the discovery was here, we could negotiate a plea. And Mr. Whitefoot's indication was, no, I want to plead guilty.
Correct.
And plead as charged to the complaint at that point. And that's what he did. And so he tendered a plea at his arraignment, and then this was set for sentences. That's why we're here in such a short time, and he waived his right to an exam, waived his right to the probable cause conference. When I met with Mr. Whitefoot, my understanding is he was very open and honest about the crime that he committed, and he committed this crime because he wanted to get caught so he could be incarcerated because he was having a difficult time finding employment. And the best way for him to have some oversight was
Be fed with the
Mr.
roof.
Whitefoot, I'm gonna give you a chance to speak here in a minute. We're making a transcript of this, so you can only have one person talking at a time. Okay?
Mhm.
Can you wait until Mr. Murphy's done? And then,
I will bite my tongue as best as I can, sir.
and wanted to be incarcerated, so there would be some oversight. But I'm trying to figure out what that oversight would be, whether that oversight is where he gets some services with help of getting employment, staying sober. But again, I wasn't able to identify any issues with substance abuse. So I'm at a loss as to what led Mr. Whitefoot to want to commit a life offense, one of the most serious offenses, with somebody who's 30 years of age with very minimal criminal history, and even his misdemeanors are very low misdemeanors, and only 2 prior misdemeanors, and then his guidelines are 0 to 17 months. There's a recommendation for 12 months, which I think all of those things are appropriate. But in representing a defendant, you try to understand the needs that they have and best tailor what those needs are. And Mr. Whitefoot has been unable to help me understand what those are. He has a completely different understanding of the system and what his goals are for him for the system to achieve for himself, and I don't think the system can do that. So I would just have the court hear from Mr. Whitefoot, but I would simply ask, I think he's not a malicious person, he's not he hasn't been, he's indicated that people have called him as somebody that's hard to deal with. I haven't had that impression. But I still, I can't figure out what led Mr. Whitefoot to get to committing this offense, given his history, given employment, given some of the things I know about him, but I just can't remember the starts. So again, I would ask the court to hear from Mr. Whitefoot and follow the recommendation.
Thank you, Mr. Whitefoot. Anything that you would like to say?
I do believe I have pled an admission of guilt to multiple felonies. So the way that I look at that, because this is law, technically I am a felon. I don't believe in like the trickle down aspect of, oh, if you plead to a misdemeanor, now you can go get like a job with other corporations, when still other corporations and other systems that are set in place, if you already accepted that admission of guilt to that felony, you are considered a felon in their eyes. And it's actually policy for multiple corporations and businesses. So I was just wondering if we could just make it to where I am a felon, this would be the 9th felony committed before we actually ask for any charges to be set for it.
You are a felon. This is a felony.
Yeah, and then, but I want the court and the people of Michigan to actually look at it as I'm already a convicted felon.
They will look at this that way. You are a convicted felon. The court records will reflect that.
Right, but I just want to make sure that it's not just like 2 misdemeanors from the prosecuting side.
It's not.
That it's like 8 to 9 felonies of
No. This is
racks.
felony safe breaking. So, so yes, you have what you're asking for.
All right.
Is there anything else that you wanted to say today?
Nope.
I did read through the report, so I'm familiar with what you did, in this case, your actions. I'm also familiar with your background and your circumstances based on the information in that report. I take all of that into account along with what the lawyers here had to say. Your guidelines in this case call for a sentence of 0 to 17 months. So the court could sentence you to no jail time, it could sentence you to county jail, or it could sentence you to prison time. Some of the mitigating factors here, or the factors that work in your favor, is that you don't have a significant criminal history. One of the factors I think that works against you is your crime in this case. This is a very serious crime. And obviously it's got a maximum of life in prison, so the legislature looks at it as a serious crime. Despite your lack of significant criminal history, I think your actions in this case justify prison sentence.
Absolutely.
And so the court is going to depart from the recommendation to the extent that I do think, given your conduct in this case, given your mental health issues, the prison sentence is warranted for purposes of punishment. I think it's up to the court also for purposes of deterrence to show the community that you're going to engage in this kind of behavior. It's going to be dealt with serious consequences.
Yeah, good scapegoat. We're good.
Yeah. You did this, so you're not going to scapegoated for anything. I also think, given your mental health issues, those are going to be much better addressed through the prison system locally here. So for all of those reasons, I find the prison sentence is warranted. The court is going to sentence you to 16 months to 20 years in the Michigan Department of Corrections. You have credit for 52 days served. The court is going to order that you pay restitution in the amount of $40,000. That's payable to the Crawford County Clerk to be dispersed to Huntington Bank. The crime victim assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, $68 state costs. You have the ability to seek an appeal of this sentence, and Mr. Chairman, if you can provide. You are right here. Yeah.
He does have his appellate paperwork, Judge.
Yeah. And then can we do more of a max? Well, that would be part of the appeal, right, Your Honor? Instead of it being like a max of 20, you know what I mean? How can I guarantee to get that 20 instead of it being, what'd you say, 16 to 20?
16 months to 20.
Yeah, and how can we just guarantee to where we just slam the hammer and it's 20 years regardless?
I don't have an answer for you on that. find that out. You are admitted to the custody of the state at this time.
Take care, Your Honor.
You did. Okay, I do have Sheboygan connected.
Okay.
And this is gonna be Ms. Shifflet.
That's Ms. Shifflet, yes.
Yeah,
It's the amount, that's the problem. That's what the issue is. That's the problem.
you can see it.
He's a dumbass, I know.
We're waiting for that. Are we ready on Mr. Marvin's case?
Is his attorney present?
Okay. Let's go on the record with People versus Marvin. This is case number 245339. Mr. Marvin, you can right up the podium there.
Yes.
If I can have counsel put your appearances on.
Your folks on behalf of the people.
James Sherman for Mr. Marvin.
All right. So this was set for a final status conference today. We're set for trial to begin next Tuesday, the 11th. So Mr. Sherman, you've been recently retained.
That's correct, Your Honor.
How do you want to proceed? Ready to proceed with trial on the 11th?
No, Your Honor, I was hoping for an adjournment. Later date. From what I understand, there was a conflict.
Ms. Cook?
There is a conflict with this. I frankly it has very little to do with it. The court staffs have been working on it, the court administration staff. It's my understanding that the courtroom is being used by Judge Burmeister in a juvenile case, and that was proceeding, and somehow that took precedence over our case.
Okay. All right, in terms of the offers, today was set, because it's the final status conference, today was set as a plea cutoff. So are you extending the plea offer given need to adjourn the trial date?
That would be fine. I offered an OWI third, dismissed the RNO, dismissed the RNO, dismissed the HAB 2, and dismissed the open intox. Mr. Marvin, who I've been in contact with because he was representing himself up until this point, indicated he is not interested in taking a plea, and it is likely to go to trial. We just asked maybe we could adjourn it out 30 days. That will give defense counsel enough time to get up to speed and we can get this case tried.
Okay. Mr. Sherman, any objection to that? Length of adjournment?
No objection.
Set for a one-day jury trial. Is that correct?
Yeah.
Okay, so the court will reset this for a one-day jury trial at its next available date. We'll set this for another final status conference. So Mr. Sherman, to the extent your client wants to consider any plea offers, that date will be the last date to enter plea in this case. Okay.
Good, thank you.
Ms. Koch, anything else that we can address for you here today?
No.
Mr. Sherman, for your side?
Nothing further.
Okay, thank you. That's all for today then.
Thank you.
Not yet. Okay, Ms. Shifflet, are you able to hear me okay?
Yes, sir.
Okay. We'll go on the record in People versus Shifflet. This is file number 255373.
here.
All right, pregnant council, put your appearances on, please.
You're cooking me up with people.
I think the other one's on behalf of the Shifflet, she's appearing in the Sheboygan County Jail.
This is the date and time set for a status conference in this matter. We also have Ms. Coe, your motion to modify the bond in this case. We can address that issue first. Can you just make a record of what you're asking the court to do?
We are asking the court to add the provisions. I don't know what's happening, but they keep getting missed recently. I think it's G and H. So what's happening, even if they are testing, it doesn't say they can't use, so. We just ask that they've always been checked and then suddenly they're just not. We ran a hearing in front of Judge Burmeister where somebody was using, but these weren't checked, even though the pretrial order said they were, supposed to test and, not use. And they're finding that because it's not in the court order, then they essentially are allowed to use substances. So she has since been arrested on a possession of meth case, but we can't do a revocation because those boxes aren't checked.
Thank you. As to the bond issue, Mr. German.
Because we don't object to that, I spoke with the Shifflet, she stipulated to the alcohol testing that normally is part of what's ordered, so.
Okay, so the court will grant the motion and modify the bond. It's requested to add conditions to the page. In terms of how to proceed with this file, it's relatively recent development, but Mr. German, have you had a chance to discuss?
So my understanding is she was arrested based on a probation violation that she was on probation for in Sheboygan County. But Ms. Shifflet, in conversations with her, was going to tender a plea in this matter, resolve this matter. There were some discussions of seeking recovery court, a drug court in Sheboygan County. So she resolves this, I think that opens the door for her up there.
Okay, what is the plea offer in this case?
Our plea offer is to count one possession of methamphetamine, the double penalty would be dismissed.
That is correct.
Ms. Shifflet, were you able to hear that?
Kind of. We talked about it last night, so I already know what was gonna be said, but it's kind of hard to hear. But I know what we did agree to that yesterday, yes.
Okay,
We
so
talked
just,
about it yesterday, yes.
all right, so just to be clear, the plea offer is that you plead guilty to the possession of methamphetamine and the double penalty enhancement would be dismissed. Is that what you discussed with Mr. Murphy?
Yes, sir. Yes, sir.
Okay, is that how you wanted to proceed today?
Yes, sir.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Shifflet, I know you're on probation there in Sheboygan County, is that correct?
No, sir, I'm not on probation, no.
Oh, okay. All right. Then you understand that the maximum possible penalty you could face for the charge in this case of possession of methamphetamine is up to 10 years and or a $15,000 fine.
Yes, sir.
With that penalty in mind, what is your plea to that charge today?
I plead guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify yourself at a trial if you want it. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
The information I have indicates this happened back on September 10th of 2024. Is that the correct date?
I honestly don't think so, but it's close to it.
Okay. Do you have any reason to doubt that date?
Do I what?
Do you have any reason to think that that is not the correct date?
I just noticed in the court file, when I read it, all the dates were off a little bit. Like there said there was a charge from April 2022 when that charge actually happened in June 2021. Or like there was another charge that said it happened in, let me see. No, it happened in March 2021 when in the paper it said something about something 2022. The dates are all wrong a little bit in the paperwork, but I was also explaining that could just be because of when the file was reported. So I'm not really sure, but it was around that time. Yes, I'm pretty sure it was in closer to October, but I cannot say 100% sure.
Okay, so the fall of 2024 though?
In 2024, yes, sir.
Okay. At that time, were you here in Crawford County?
Yes, around that time, yes.
Okay, and when you were here, did you have, in Crawford County, did you have possession of some methamphetamine?
I did, yes, sir.
Did you know that that's what that substance was?
Yes, sir.
Did you have any legal right to have any amount of it at that time?
No, sir.
All right, thank you. Ms. Koch, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Gerber?
Yes.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Gerber?
No, sir.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
And I agree.
Thank you. Ms. Shifflet, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Do you know how long you're going to be lodged there in Sheboygan County?
I was supposed to bond out yesterday, but I couldn't make it to court in person today for you guys, so they're gonna let me bond myself out after this.
Okay, so you think you're going to be released there?
Yeah, I can be released here as soon as I get done with court.
Okay, so do you have a good number for me?
I do. She's kept in contact with me.
So Mr. Germer, I'm sorry, Mr. McFadden, if you can get that number from Mr. Germer, please.
Okay. I'll email it to you.
Ms. Shifflet, somebody from the probation department here in Crawford County is going to be in touch with you at the number that your attorney has. When they call you, it's very important that you follow up with that phone call and that you participate in that pre-sentence report, okay?
Okay, yes, sir.
And then the court's going to set this for a sentencing hearing. We're going to send that notice of date and time of that hearing to you in the mail. But it's also important that you stay in touch with your attorney so that you're aware of that date and you're ready to go forward at that time. And that hearing will be here in person in the courtroom in Crawford County, okay?
Okay, yes, sir.
Okay, Mr. Germer, anything further today?
No.
Let's go.
No, thank you.
Ms. Shifflet, do you have any questions at all?
No, sir.
Okay, thank you. That's all for today. The court's going to disconnect at this time. Do we have Mr. Ross present?
Yes.
People versus Patrick Ross, case number 245352. Mr. Ross, do you want to come up to the podium here, please?
Sierra Coke on behalf of the people.
I think you're right to go with Mr. Ross, Judge.
Okay, my notes indicate that Mr. Ross was not here at the last hearing back.
Right.
discuss that with Mr. Ross?
I did, Judge. Mr. Ross had some medical issues and then I think simply forgot about his court hearing last time.
Well, they counter and, they slashed at the same date. Actually, I had reconstructive surgery scheduled for that date as well. I've had a colostomy bag since April and I just had the reverse like a week or two ago, a couple of weeks ago.
All right, and people do have medical issues from time to time. It's important that you communicate with your lawyer so that if you can't make it to court because of a medical issue, that we can get that addressed ahead of time.
I thought I had, but evidently not, sir.
So I'm not gonna, impose any kind of penalty on you this time, but again, it's important to the extent that happens and that we get it taken care of before the date of the hearing.
Well, I understand, and hopefully there shouldn't be any more medical situations at the time.
All right, in terms of how we're gonna proceed with this case, Mr. Murphy.
Judge, Mr. Ross was gonna plead to an attempt, 2.5-year felony, and count one would be dismissed.
Ms. Koch, is that a correct statement of the offer?
It is.
Mr. Ross, have you had a chance to talk to Mr. Murphy about this plea today?
I don't think we really discussed much of it. If you can give us a few minutes.
Yeah, we can do that. So why don't you take some time here, 10 or 15 minutes, talk to Mr. Murphy. I'm gonna take some other cases and then we'll recall your case, okay?
Okay, thank you.
Mr. Isles, we're ready on your case. This is Michael versus Mr. Sylvester. You can come right up to the podium. Michael versus Sylvester, file number 245367. If counsel can put your appearance on.
Sierra Coke on behalf of the people.
Scott Isles, on behalf of Alex Sylvester.
This case today, we're set for a status conference. We do have some other issues with regard to Mr. Sylvester that we'll discuss in a second here, but I was going to tell me the status of this file.
Your Honor, quite frankly, Ms. Koch and I are working towards a resolution. I needed to get some information to her, and I've been somewhat dilatory in getting that done because of other issues I've been dealing with. We anticipate that this matter is going to resolve itself down the road. If we do go to trial, we would waive jury, and I wouldn't anticipate one day. More than sufficient.
When do you think, if this is going to resolve in a plea, how long is it going to take?
I think it's going to resolve in a dismissal.
Ms. Koch?
Mr. Isles indicates he has some documentation to show me. I have no such documentation. So if you want to adjourn it 30 days, the plea offer will stay open for 30 days and I can review whatever documents he has. Otherwise, we can proceed to a bench trial.
All right, is that enough time for you to get Ms. Koch?
Yes, Your Honor.
All right, so I'm going to set this for a plea hearing status conference in 30 days. If we don't have a plea at that time, the court will set it for a bench trial that date. So that'll be a plea cutoff in 30 days. The other issue we have, Mr. Sylvester currently has an open warrant from a different jurisdiction. So we're going to take him into custody here today. And then I believe he needs to be fingerprinted on this charge in our jail also. So they'll accomplish that. Do you know where that warrant is?
I'm not sure which county it is from.
So Mr. Sylvester, we're gonna need you to go with the officer here today, so you can address that warrant.
Okay.
So have you go with the officer.
Call me when you know where you're going.
Okay, will I be able to call anybody? So someone can get my kid from school?
I don't know how the jail operates on that, so.
I'll see if I can find out. I didn't know. I'll send you a text if I.
He got this stuff to me last night.
Okay.
That's how it always is with dealing with him. So I'll put them all together in a nice way.
We'll take a short recess and go back on the record.
Let me see if Rachel knows what he's, and then I'll send.
To the podium, sir. Record should reflect back on People versus Patrick Ross. Again, file 245352. Mr. Ross, did you have a chance to speak with your attorney about the plea agreement?
Yes, I did, Your Honor.
Is that how you wanted to go forward today?
Yes, I did, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And Mr. Ross, are you currently on any kind of probation or parole?
No.
And you understand that by pleading guilty to an attempted possession of a firearm, unlawful possession, the maximum penalty you could face would be up to 2.5 years? You said yes or no?
Yes, sir.
And with that in mind, what is your plea to that charge today?
I plead guilty as you spoke.
Okay, I'm gonna go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want. You understand all those rights?
Yes, I do, Your Honor.
You tell me what will happen to those rights by you pleading guilty.
I will guess I'll be giving those up.
That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. If you want to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of that appeal. You understand that?
Yes, I do, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, they have not, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, it is.
And are you pleading guilty because you are guilty?
Yes, sir.
This happened on September 25th, 2024. Is that the correct date?
I believe so, yes.
And on that date, were you here in Crawford County?
Yes, sir.
You have possession of a firearm.
Yes, I did, Your Honor.
And were you prohibited from having firearms based on a prior conviction?
Evidently, yes, sir.
Ms. Koch, are the people satisfied with the factual basis?
Yes, Your Honor.
Yes, sir.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
The weapon will be forfeited.
Okay, you understand, Mr. Ross, that by law, the court is going to seize that weapon and dispose of that. You'll be able to get that weapon back.
From what I understand, Your Honor, I gave them 4. And which one, because you said 1, is there one in particular that you're speaking of?
I didn't realize there were multiple weapons. I believe all of them, right, Ms. Koch?
It is required by statute, yes.
So-
Well, actually, they're family heirlooms that I inherited when my father was passed away. And right now, my brother went down to the city or whatever to file for rights to them or something like that, so we could keep the weapons. They won't be in my possession, but rather than have them destroyed or something along that line, because they are family heirlooms, we'd like to keep them.
So Judge, I would just simply state for statute, Mr. Ross would not be able to have the weapons, so he would be forfeiting his right. He doesn't forfeit the right of his brother or family member to retrieve them. So as long as that is clear, those 4 weapons, Mr. Ross would not have in his possession or retrieve them, but somebody
will
else in
not.
his family would.
Yeah, they will not be in my possession.
Your Honor, I wasn't aware of this issue until right now. I will talk to the forfeiting agency, and I will review the statute. We can deal with that issue at sentencing.
All right, so I will say this, Mr. Grimmerty and Mr. Ross. We're gonna proceed with the plea today.
Okay.
If for some reason this issue of these, who can retrieve, if anyone, these firearms becomes a problem such that Mr. Ross would want to withdraw his plea, then the court will allow him to withdraw his plea at sentence for that reason only. So, Mr. Ross, if it looks like even your brother can't get these weapons based on the state of the law, then I will allow you to withdraw your plea here today, and you can have further negotiations, or you can take the trial, you get all those rights back, including the right to have a trial, okay?
Okay.
Mr. Germer, the other thing we just discussed, are you aware of any other threats, promises, or inducements?
No,
So, are the people satisfied that the court has complied with statute and court rule?
Yes, Shannon.
yes,
All right, Mr. Ross, the court finds your plea is knowing, voluntary, and accurate. The court is satisfied with the factual basis to support finding that you are guilty of the attempt. The court will accept your guilty plea to that charge. We will set this matter for sentencing hearing and be notified of the date and time of that hearing. It's important that you stay in touch with your attorney prior to that date. Okay, go over the sentencing report and be ready for the hearing on that day. Before you leave today, you're going to meet with the probation department for that pre-sentence report. Okay.
Okay.
Thank you.
Thank you. Okay.
People versus Clear, case number 245360. I can have counsel put your appearances on.
Sierra Coke on behalf of the people.
I think I have a good resident on behalf of Mr. Clear, was just going to.
Have this set for plea hearing today. Is that how we're going to proceed, Mr. Gordon?
It is, Judge. Mr. Clear is going to plead to a possession less than 25 grams. That's a 4-year felony. And 25 grams is a fine. More serious offense, possession of methamphetamine. Excuse me, will be dismissed.
Ms. Cope, is that a correct statement of the plea offer?
It is.
Mr. Clear, have you had a chance to speak with Mr. Gurmurthy about this plea agreement?
Yes, yeah, we just did.
Okay. Is that how you wanted to proceed today?
Yes,
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
yes, yes, I do.
Mr. Clear, are you currently on any kind of probation or parole?
No, I am not.
You understand that like pleading guilty, this is an added count 2, is that correct?
That will be correct.
This added count 2 of possession of a controlled substance is up to 4 years and or a $25,000 fine. Do you understand that?
Yes, I do.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during the trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, I do.
You understand that you're giving up and waiving all of those rights, including the right to have a trial.
Yes, I do.
Also, you don't have an automatic right to appeal the plea making here today.
Okay.
If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case.
Okay.
If they said no, then you wouldn't be able to go any further with that appeal.
Okay. Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, they have not.
Has anyone promised you anything other than what was said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty because you are guilty?
yes,
We're taking the factual basis to the method.
Yes, sir.
This happened, Mr. Clear, on or about October 2nd of 2024, is that correct?
yes,
On that date, were you here in Crawford County?
yes, I was.
And when you were here in Crawford County on that date, did you have possession of some methamphetamine?
Yes, residue in the cellophane.
Okay. Did you have any legal right to have any amount of it at that time?
No, I do not. No, I did not, I should say.
Ms. Koch, are the people satisfied with the factual basis?
Yes,
Defenses too, Judge.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
no, I do not know whether he's eligible for 7411 because he has a 2010 out of state case in Pennsylvania, and I wasn't able to ascertain whether or not from the CCH I had, whether he was eligible. So I just want to put that on the record. It's not part of the plea, and I don't know whether he's eligible.
Just my review of this history indicates, I don't believe that he would be 7411 eligible because there was a prior drug conviction out of state.
Okay.
But I can certainly look into that further and I can see if probation with them. They would have a better idea if that's the situation.
Because I've never had one before. And when I was incarcerated when they arrested me, the lawyer that was there, was that your arraignment, 1 year in jail. And the first one you go to, he said that he thought I was eligible. Just by what the information he had and the information that I gave him, he thought that I should be eligible because I've never had a felony. And I had a drug charge when I was a minor. It was a deferred sentence, not a 7411. And that was erased off my record. That was a long time ago. And then that one in Pennsylvania is really messed up. And that's why it's such a pain because I don't even know what the actual charge is.
Okay, well, whether you're eligible for 7411 or not, you would not be able to withdraw your plea.
Yeah.
So, if it turns out that you are, that's something the court will consider, but if
Okay.
you're not, the court was sentencing anyway. Okay.
Okay. Yep, I understand.
Ms. Koch, are the people satisfied that the court has complied with statute? The court will be taking this plea.
I am, Your Honor. Thank you.
On the defenses as well, thank you.
Mr. Clear, the court finds your plea is knowing, voluntary, accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. You're going to meet with Mr. McFalda to set up a pre-sentence report today.
Okay.
And then make sure that you stay in touch with Mr. Murthy so that you're aware of your sentencing date. We're going to mail you the date and time of that, but make sure you stay in touch with him. And that you're prepared to go forward with sentencing. Okay.
Okay, thank you.
Some of those letters.
Yep, I will. As soon as I get them all, I'll get them. I'll get them to you and for the judge.
People versus Brian Crawford.
Judge, Mr. Crawford's here. I just need a few more minutes with him to navigate this understanding of his plea.
Okay.
But Mr. Thompson's, I just spent a few minutes with Mr. Crawford.
Mr. Thompson, were you ready for the arraignment for Mr.
Yes.
Butts? Mr. Butts, do you want to come over to the podium? Mr. McFalda a chance to in here, but for the record, this is People versus Butts, case number 204727 214739. Butts before the court today for arraignment on probation violations in both these files. You've been given a copy of the alleged probation violations.
I might have, sir, if that could be in myself. Not really sure. There's some papers back there.
Yeah, I do have an extra copy, so I'm gonna give this, but we discussed it, but this way we know he has a paper copy.
So, Mr. Butts, you were able to go through this with Mr. Thompson.
Yes, sir.
Do you understand what the alleged violations are?
It says I was drinking. I allegedly assaulted Angela Ray.
Correct. So I'm going to go through a few things with you with regard to your rights as to these violations. First of all, you do have the right to have a hearing in both files as to whether or not you did violate your probation as alleged. You also have the right to have an attorney present at that hearing or any other hearings. If you can't afford an attorney, one would be appointed for you. If you are found guilty of violating your probation in file number 4727, That's the file where your underlying charge is of possession of methamphetamine, that's up to 10 years. Other file,
It's the same underlying top charge.
also up to 10 years. You understand all those things that I've just stated to you.
Yes, sir.
Requesting a court appointed attorney.
Yes, sir.
Mr.
He has been screened. Mr. Trush is appointed on this file, Your Honor.
Okay. So, the court will order that counsel be appointed as indicated by Mr. Thompson. We'll set this matter, both of them, for hearings. Mr. Felda, anything regarding bond pending those hearings?
Judge, he's already out on bond on a prior violation. It's serious, it's a home invasion, he's charged up in Gaylord. And his trial has been pending. Just trying to look up, kind of catch up here, I'm trying to look at the date.
Last time he said Charles in March, he served on a PV hearing on 4/21 at 9:15 this court. It was just a report here not too long ago. The jury got out.
The original home invasion happened back in June of 24, so we're gonna be pushing a year. We've been waiting for this trial to get resolved up in Gaylord. For whatever reason, it's just really taken a long time, and then subsequent to that, he's arrested on a domestic violence charge just the other day. And was consuming alcohol. So
I'm gonna.
Judge, I just asked his bond be revoked. I mean, I don't really know what else, what other recommendation to do, if not high cash bond.
Your Honor, Mr. Butts is requesting bond in this matter. He wants to make sure the court understands. He has obtained a really good job at MEC. He's working in a factory. He's making almost $20 an hour. He's been there for 6 or 7 months. He really values his job. He also has full custody of his daughter. He's providing care for her. He is requesting the court address bond. I can't really speak to this old home invasion charge. It's not my case. I don't know anything about it. This charge, I know that the person who's listed as the alleged victim has already contacted my office, asking that charges not be filed. I know that's not completely unique to cases like this, but I did want the court to be advised of that. Mr. Butts is asking for a bond. He does appear in court historically, is my understanding. And as indicated, he's got a felony trial coming up. He's got a lot to work for and to report to court for. So would ask the court to consider a $10,000 bond with a 10% option. Thank you.
All right, Mr. Butts, anything else that you wanted to say today?
No, I just really can't afford to lose my job and get my daughter to go back to her mother's. It took me a long time to get her. These are alleged. I didn't assault nobody. I don't know. I'm here. I don't know what really to do other than more than ask you if I can get a bond. I got to get my daughter going. I don't want to lose my job. I was arrested at my work working on my boss's vehicle on a Sunday. I don't even think he really truly knows what's going on. I just would really like a bond, be able to talk to my daughter and let her know what's going on. That way I can at least, if things go wrong, get her back to her mother, which I don't want to, but you know what I mean? That way she knows what is going on. A bond would be very appreciated. I know I've been accused of a lot in life and I've done wrong in life, but if you just give me this chance, sir, you'll see that it will all come back.
All right, number one, I think the court should grant a bond. I don't think I have a high bond in this case completely. I do think it should be a high cash bond given the status on these files. So the court is going to set bond in the amount of $25,000 cash and surety in each of these files. And the court will set this for hearing within 14 days as required by statute. If you're unable to post those bonds, so that this part of it can get resolved. There, Mr. Thompson, any further?
Nothing further. I'll get the file to Mr. Cruz. Be advised the court's ruling today. Thank you.
Mr. Fellow.
Just let Mr. Butts know, contact me back on my supervision if you do postpone.
Okay, so you don't feel all adjusted no more?
No.
Okay, I see, that's what I didn't know what was going on.
That's why I'm telling you right now.
Sir.
Every time you get a warrant, you come back to my case, and so I supervise you.
Okay, I didn't.
All right, that's all for today, Mr. Phelps.
Thank you, Honor. It's 25,000 cash assured. That's what the court just ordered. So, yeah, so it's not 10%, it's 25,000.
Thank you.
Mr. Thompson, were you ready on Mr. Belot's case? Yeah, we're really,
I would just check in with him. Did we approve some of this?
As far as I know, it's an interesting hearing.
All right, I'll see if he's in the lobby.
let's take a short recess and we'll come back on. Thompson, are you representing Mr. Hill for agreement?
For duty, yes, we're prepared, Your
Mr.
Honor.
Hill, you want to come over to the podium, please? We're on the record now in People versus Thomas Hill, file number 245287. The record should reflect Mr. Hill is present here in court today. I could have counsel with your appearances on.
Here, Coke, on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Thomas Hill.
Okay, Mr. Hill, you're before the court today for arraignment on 2 alleged probation violations. Have you been made aware of what those are?
Yes, sir.
Do you understand what the charges are against you?
Yes, sir.
Okay, I need to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you did violate your probation as alleged. You also have the right to have an attorney present at that hearing or any other proceedings. If you can't afford an attorney, one would be appointed for you at public expense. If you are found guilty of the non-technical violation, it could subject you to a maximum possible penalty of up to 2 years, which is that of your underlying charge. Do you understand those things I've just stated to you here today?
Yes, sir.
All right, Mr. Thompson has no request for court appointed counsel in this case.
He has, he's been screened and qualified, and Mr. Garamuthi will be appointed, Your Honor.
Okay. Have you talked to Mr. Hill about how he wants to plead today?
Yes, he would request a hearing at this time, Your Honor, and plead not guilty.
Okay, so the court will enter not guilty plea on your behalf, Mr. Hill, with regard to both alleged violations. We will set this for a hearing in terms of bond pending that hearing, Mr. McCullough.
Judge, I know he's charged OWI third. And I think they set a bond at 10,000 cash surety in that court. I think something similar to that would be appropriate on violation.
Mr. Thompson.
Your Honor, I understand a cash bond would be appropriate here. Mr. Hill does have employment, works as a diesel mechanic. I believe my understanding from him is he's been reporting to probation. I don't believe he would be a significant risk of non-appearance. I believe the court could order conditions like alcohol testing to reduce the risk to public safety, and would ask the court to consider $1,000 bond. Thank you.
Mr. Hill, was there something you wanted to say?
Yeah, Mike does know, I just lost my 6-year-old daughter. Not yesterday, but the night before. Kind of like to be there for my girlfriend and kind of try to set up arrangements for a funeral or something. I already got to come up with $1,000 on the other one. If you could, I'd like a lower bond.
What is the bond? What's the bond on the other case?
10,000, I believe it's, I don't know if it's 10%.
10%.
All right, I'm gonna set the same bond. In this case, I'm very sorry to hear about what happened. I wasn't aware that that's the underlying circumstances, but I can know it's Mr. Hill. The court will set a bond at $10,000, 10%. In this case, and we'll set for hearing. Mr. Rickfeld, anything further we need to address on this case?
No, Judge.
Mr. Thompson.
Nothing further. Thank you.
Thank you. That's all for today, Mr. versus Wells, case number 245359.
You're calling back people.
Mr. Wells.
Reflect Mr. Wells is present here in the courtroom today.
Judge, Mr. Wells is aware of his plea offer and to the trial date. He's rejected that offer. The matter was set for trial for April 14th and 15th, and we would proceed forward by the trial.
Mr. Wells, have you had a chance to discuss this with Mr. Gerber?
Yes, here and there, we'll be talking more.
Okay, but in terms of accepting or not accepting the plea offers,
I've
discuss
talked
it.
about that.
Okay, and that's how you want to proceed. So are the people going to be ready to go forward with trial in April?
Yes. Yes,
Okay.
sorry. I said it.
The court will set this for one final status conference on the motion day immediately preceding the trial date. Ms. Cope, are you anticipating any motions in the day to be filed?
I don't think so.
Yeah, we don't anticipate any motions even at this time.
Okay. Ms. Cope, anything else we need to address if we have people today?
No.
No.
So, Mr. Wells, just make sure that you stay in touch with your attorney as we get closer to the trial date to make sure that you're prepared to go forward on that day. We'll also have one final status conference prior to that trial date, so I can address with counsel any issues that before we have trial. Other than that, again, just stay in touch with Mr. Gerber. Okay.
I will, sir.
Mr. Gerber, anything?
No, sir.
Thank you. That's all.
Thank you.
Versus Crawford, case number 245358.
You're calling back with people.
Hey, Mr. Crawford, who's extended tonight.
Mr. Gerber, if you have
Does have some negotiations with Ms. Cole. She's going to offer an added count 4, an attempt larceny, which is a 2.5-year felony. Count 1, the official fourth offender notice, count 2, and count 3 would be dismissed. And I would ask the court if I could elicit factual basis on this matter from Mr. Crawford.
Ms. Cope, is that a correct statement of the offer?
It is.
Mr. Crawford, have you had a chance to discuss this with Mr. Gerber?
Yes, sir.
Okay, is that how you want to proceed today?
Yes, sir.
I know we kind of went through some of this before, but I'm going to go through it with you again today, okay? Just to make sure that nothing has changed. So if you would, please raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Where you again? Mr. Crawford, you're not on any kind of probation or parole, is that correct?
No, sir.
You're not on probation.
Yeah, no, I'm not.
You're not. Okay.
No, yeah.
And then you understand that the maximum penalty you could face for the attempted larceny in this case would be up to 2.5 years.
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty, sir.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea today. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to this charge because you are guilty?
Yes, sir.
Thank you. Mr. Crawford, just turning your attention back to August 10th, August 11th of 2024. Were you here in the city of Grayling?
No, not in Grayling.
Okay, were you in Crawford County?
Yeah, Crawford County, yeah.
Okay, were you in Grayling Township, or just outside of the city?
I'm not positive what town, that would be Lowell Township.
Loveless Township, okay.
Yes,
And on that day, did you take a boat motor?
yes, sir.
And you did not pay for that boat motor, correct?
No, sir.
And you took that boat motor and put it in your ORV,
Yes, sir.
and you drove down a trail,
Yes, sir.
and you laid on the side in the woods of the trail, is that correct?
Yes, sir.
And then you came back at a later date,
Yes, sir.
and you took that boat motor,
Yes, sir.
and you took that back to your property.
Yes, sir.
And you still at that point hadn't paid for it, correct?
I had not paid for it. No, sir.
And you agree that the boat motor had a value of at least $600?
From what I'm told, yeah.
Okay. I think we have a factual basis for the elements of larceny, the attempt larceny.
Ms. Coe?
I think we have the elements as well.
Ms. Coe, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, I want to put on the record, I think we normally do this as an attempt to count one instead of an added count four. We just do it different in both, in different courts. So it's the same charge, it's just done procedurally different.
Mr. Gummer?
No, nothing further.
Ms. Coe, are the people satisfied that the court has complied with statute?
Yes.
I would agree to this.
The court finds that Mr. Crawford, your plea is knowing, voluntary, accurate, or is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Today, you're going to meet with somebody from the probation department. Court. Cooperate with that, and that you stay in touch with Mr. Crawford. Thank you, that's all.
And just for the record, the trial, jury trial was scheduled for March 12th.
Yeah, in light of the plea, the court will. Okay, Mr. Thompson, were you ready with Mr. Belot's case?
Yes, sure, thank you.
This is file number 255369 versus Michael Belot.
Sierra Coke on behalf of the people.
Sir, if you come right up on the podium here, the record should reflect that Mr. Belot is present here in the courtroom today. The date time set for sentencing in this matter. Sir, have you had an opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, I have.
For the record, Mr. Thompson, the court did receive letters from Mr. Bonner, Mr. Call, received assessment, driver safety plan report, prepared by Ms. Baker. Did receive a report from Community Corrections, Ms. Anderson. Are there any other letters, Mr. Thompson?
Those are the ones I have.
Okay.
I think the court was accurate.
Okay, so I had a chance to review all those prior to the hearing today, including the one from Mr. Bonner, which the court just received a few minutes ago. So I have reviewed those for the record. Are there any additions, deletions, or corrections to the report?
No, Your Honor, thank
Any challenges to the score?
you. No, Your Honor.
Just like, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the score?
No, Your Honor.
Anything on behalf of the people for allocation?
I read a lot of drunk driving cases. When I read this one, I thought he's doing 109 miles an hour. I mean, that's crazy in itself. And then you add his, PVT was 0.194. He's lucky to be here, I think. He's lucky to have not killed himself or someone else in that situation. He probably knows that. It's a pretty dangerous situation. I mean, the recommendation's 120 days and 3 days served. I think that's probably pretty practical. I think even if he's sitting in jail, he's lucky to be there considering where he was, and I hope that he uses his time. The lab results were 0.203, so he certainly has a drinking problem. He seems to know that. He's tried to go through AA. I've read all the things that say he's trying to get clean. I hope that he takes this seriously. I think he's getting way too old for this behavior, so.
Thank you.
Thank you, Your Honor. Yes, this was a very disappointing relapse. Mr. Belot is very disappointed. He had successfully done sobriety court in Wisconsin in 2020. There's reference to that. He had successfully done sobriety court. He was on a still a restricted sobriety court license from Wisconsin. He had been doing well. He had been sober. His father was passing away, is my understanding. He did relapse, and that led us to where we are here today. He is committed to becoming sober again, to utilizing those same resources that had helped him in the past. That's why he went to this Miss Baker. He indicated that facility is open to doing inpatient, but he understands he has to, deal with his court sentencing first, so he hasn't scheduled that at this time. He's asking if the court would consider making that inpatient an option for him within this court sentence, because he does believe he would benefit from a 30-day inpatient program with this program in Wisconsin with Ms. Baker. He did sign up for everything essentially he could sign up with, which was outpatient treatment. He's very concerned about what happened. He's taking this very seriously. He understands that the court is going to punish him today, but he is asking the court to include that inpatient as part of his sentence today. Thank you.
Thank you. Is there anything that you wanted to say?
No, Your Honor, that's pretty much something. I mean, I feel so let down myself. Yeah, I'm strong in the program. I mean, I go to 5 meetings a week. They all know me. We're all a bunch of guys that, all have the same problem. I'm the youngest one there in sobriety. These guys got 45, 38, 25 years of sobriety. And I work with them a lot. I hang with them. I don't associate with any other people other than my wife and my family. And I'm retired, so I get to apply a lot of points to it. My mission is just to help somebody else with the same problem, because I've been there.
All right, I did read through the report, familiar with what happened in this case. I'm also familiar with your background and circumstances from the information in that report, along with the letters that were submitted. So I take all of that into consideration, of course, along with what the lawyers had to say here. I think there are some positives. Clearly, you've taken this seriously in the past. You've undertaken a lot of actions to try and address your alcohol problem. Right for treatment. So I think you do understand that it's something that you're not going to be able to do on your own, you can't do on your own. Yeah. So I think it is encouraging that you're looking at what you can do to prevent this from happening. There's a lot of concerning things about this circumstance. Number one, it's your 5th conviction for drunk driving related offense, which tells the court that over time you continue to engage in this behavior, even knowing how dangerous it is for yourself. And I'm not just talking about consuming alcohol, I'm talking about consuming alcohol and getting in the car driving. Because it's one thing to have a problem with drinking, it's another thing to compound that by putting other people in danger. This circumstance is really concerning. I think it's totally understandable that you relapse given what's happening in your family, your father. that's the kind of thing that can set people off. That's understandable. What's not understandable is putting other people at risk because of what's happening to you. The witness statement here that you almost ran into a truck carrying a wide load and knocked the flag off of that. I mean, you could have easily killed yourself. You got those folks and anybody else that you encountered on the road are just going on about their day, have no idea what's going on with you and your father, and don't deserve to be injured or killed because you're feeling bad about what's going on in your life. They're just innocent people trying to go on about their day and put them all at risk here. And not just theoretically, I mean, from the witness statement, you actually put that vehicle at least at risk. And that tells me you've got some ways to go if you're willing to be so selfish that you're only thinking about yourself and the pain you're going through and not about what you could have done to other people. Because of the seriousness of your conduct here, because of the danger that you pose, because it's the 5th time now, I think a substantial penalty is appropriate. I do think building an opportunity for treatment into that is also appropriate. I think probation is appropriate so that there's a level of supervision for a period of time. So the court is going to place you on probation for a period of 2 years. The court's going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to sentence you to substantial jail term. The guidelines are 0 to 11 months. The court's going to sentence you to 11 months in the Crawford County Jail. You do have credit for 3 days served. Required that you serve the first 9 months of that. You can be released to treatment after that 9 months, whether it's a 30-day program or a 60-day program, or whatever it is. If you successfully complete that, then you would not have to come back and serve the remainder of your sentence and be given credit for the time that you're in rehabilitation. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, and a supervision fee of $30 per month while you're on probation. You have the ability to seek an appeal of this sentence, and Mr. Thompson's going to provide you with some papers that explain to you what your health rights are, as well as how to request a court county lawyer to help you with an appeal.
These are the papers you utilize for an appeal. Right now, we're asking you to initial and date that to say that you've received it. You'll keep the bottom copies. This initialing is not filing an appeal, it's just indicate you received it. If you wish to file an appeal, you would fill out the rest of the form and then type that out. And that would start the appeal process. Ms. Medler, here's a copy of that. All right. All right, you're gonna go with this gentleman right here.
Can I grab my stuff that I talked to the jail? They said I could bring some long guns. I got all my meds and stuff.
I'm gonna read that up to the courthouse.
Thanks, your phone.
Yeah. Okay. Do you want me to grab those? Do you want me to have her go turn around? Sorry.
Our next hearing is set for 11:15. All right, we'll go on the record in file number 2411698, which is the file for the petition for foreclosure of parcels or unpaid taxes for the year 2022. Council, if you would put your votes on the record, please.
Charles Lawler, P65164, on behalf of County Treasurer Kate Wagner, who's sitting here to my right, Your Honor.
Okay, thank you. This is set for hearing prior to the court signing an order for foreclosure. I did review the file prior to today's hearing to confirm that all the statutory requirements have been met. It's my view after reviewing the file that they have. I know that there was an original petition filed. An amended petition was then filed, I think, beginning in January of this year. So, Mr. Lawler, was there anything that you wanted to address for the record?
Yeah, just a second, just for a moment, Your Honor. I just want to get in the record, and same as we've done previously in some of our other meetings together, that we filed on behalf of the treasurer an affidavit of title search, which is a affidavit stating that the treasurer or representative of hers has made us a title search of all the parcels of property that were subject to foreclosure for delinquent taxes. And that allowed them to notify any person or entity who may have an interest in the property later. Then we also filed an affidavit of personal service, which means a representative of the treasurers went out to each parcel, tried to personally serve the resident with a notice of the show cause and foreclosure hearing. If they couldn't notice somebody, they posted the property and took a picture of it. And we have it in our files at the treasurer's office. We also filed, Your Honor, an affidavit of publication, which means that all the parcels that were subject to foreclosure were published for 2 consecutive weeks in the Crawford County Avalanche as required by statute. And then finally, Your Honor, we filed an affidavit of service of the notice of show cause and judicial foreclosure hearing, which was sent via certified mail. And that gave us that identified everybody of their potential to go to a show cause hearing to work out an arrangement with the treasurer or to come here and meet you in person. So the one thing I want to note, Your Honor, is on our exhibit list that we have, I've written in the second parcel on the first page. The treasurer's entered into a payment plan with that person, so we're going to withhold it because of a payment plan. I also note that there's a taxpayer sitting here. I'm not sure if he wants to speak to you or not. You want to speak to the judge?
Sir, can you tell me your name, please?
James Card.
Okay, Mr. Card, was there anything that you wanted to state for the record today?
Young man, or Your Honor, I really don't, I don't really know what to say.
Your Honor, Mr. Card went to pay his taxes at the township office on the last day they were supposed to be paid, and the office was closed. So
At 2 o'clock in the afternoon.
So he went the next day to try and pay him, and
At 11.
They wouldn't take his payment, and they slapped him with a penalty. So we're here today. The treasurer is working on his problem, so we think we're gonna be able to take care of it. There's not gonna be an issue. If there is, we'll come back to you. Or the judgment I have is the judgment that we have used in the past. It gives the treasurer some leeway to make special arrangements without us having to have leave of the court. So we don't take Mr. Card's house.
Okay.
I think
Any
that's
questions about that?
I mean, obviously, Your Honor, this is a bigger issue, but that's where it started, was that day. And I was really frustrated. I just, not knowing the consequences, I'm done trying. I didn't have a clue what I was getting myself into by just saying, screw it, I'm done being an adult. Because that's pretty much what I did. And that's how I ended up here today.
Okay. All right. The court's not going to take any action on this unless and until there's an issue that arises with the resolution that the two of you have come up with.
Okay.
That was the time to take it up at that time. But your appearance here today and your statements are preserved for the record, Mr. Card. This was set as an in-person hearing. I do have 2 individuals in my Zoom waiting room that I would like to bring in. I don't know if they're calling.
Okay, that's good, Your Honor. Do you mind if I sit down or?
Absolutely not. We have an individual calling in with the last 4 digits of 3302. Can you tell me your name, please?
Joe and Cheryl the Portage, the lawsuit with, hang on, I don't know how you're.
Oh, that's Schroeder Family Trust matter?
Yeah, Cheryl, yeah, the trust matter.
Okay, all right, I'm gonna put you back on hold. We have that set for 2:30, so you can disconnect.
2:30,
Correct,
so I should call back at 2:30?
yes.
Very good.
Okay, thank you.
Do you need a file or anything like that? Any kind of I don't see an order of any sort, but it's, yeah, Cheryl's and, it's Cheryl's Aduni.
Okay, yeah, just call back at 2:30. That's when that hearing is scheduled for.
Okay, thank you.
Thank you.
Miss Kate, am I all set now? Am I done?
Yeah, you're free, you're free.
Your Honor, thanks for your time.
You're welcome.
Do you wanna leave me your number and I'll call you when that meeting comes?
I'll just,
Call me next week?
I'll probably give you a call Monday, Tuesday.
All right.
Because the way she said it was being
Ma'am,
sent
who's
tomorrow.
calling in as Sheila? Can you tell me your name?
Thank you.
Sheila Fortino.
Okay, ma'am, your matter is scheduled for 2:30, so if you want to disconnect and reconnect at that time.
I will do that. Thank you.
Okay, thank you. And sir, can you tell me what case you're here for?
I forgot what it says. I think I messed up and I didn't send in for reply to divorce papers.
Can you tell me what your name is?
Shimel, you want this?
Mr. Shimel? Yeah, okay. Your matter's, no, that's fine. I got you. Your matter's set for 2:00.
Yeah, I know. I was worried I didn't make it here. That's why I look like I do. I just parked my semi and got here.
Do you have a cell phone or a way to sign in by Zoom?
I'll just do it in person if you don't mind.
Well, the problem is the other party's appearing by Zoom.
Yeah, because she's in Kentucky.
Well, I know, but do you have the ability to sign in through Zoom?
I guess I can call in, yeah.
Okay, then I'm gonna ask you to do that. It was set as a remote hearing and we're gonna be closing the courtroom after this hearing. Because all of our afternoon hearings outside of this one are set to be by Zoom. And when we have one party by Zoom, I need to have everybody by Zoom.
Oh.
Okay.
Okay, so I guess I'll go out in the car and wait.
Yes, sir.
All right, thank you.
Your case is set to start at 2:00, so that's 20 minutes from now.
So call in at 2 or 5 minutes to or what?
Yeah, 2:00 is good.
Okay.
All right, thank you. I appreciate that.
I just seen notice to appear and I don't want to get in trouble and have a warrant while I'm driving a big truck.
Thank you. I appreciate that. Okay, so no one else has appeared. Just a note for the record, it's now 1:40. No one else has appeared on this matter. So Mr. Lawler.
I've got a judgment I'd like to present. And can we go off the record for something? Just a second, too. Just I want to tell you something. The record.
I just grabbed a file, gave it to you. I'm like, I didn't even read it.
Hello, whoever's connecting on the phone, can you tell me your name, please?
Timothy Shimel.
Okay, Mr. Shimel, thank you again for connecting remotely. I appreciate that. We'll go on the record in your case. This is Shimel versus Shimel, file number 2411808, I'm sorry. The record should reflect that Mr. Shimel is connected by phone for this hearing today. Ms. Shimel has not connected. Mr. Shimel, this is a pretrial hearing in your divorce case. The purpose of this hearing is for the court to determine whether there are issues regarding the division of any assets or debts of the marriage, or whether you and Ms. Shimel have been able to reach agreements on that. Can you tell me whether there are disputes between the two of you about how to divide things up?
There are no disputes, and the letter that she left me when she left the house said that I could have the house and she wanted the car. She's not disputing anything. I just talked to her a few minutes ago and she said she did not get this letter. So that's why she's not talking to you either. But I have a handwritten letter from her stating what I just told you about the house and the car. So we have no disputes. She's just walking away with the car and her personal stuff, which I have no issue with.
Okay.
Notice went to the last common address. She has a different address. She updated with me. No mail was returned.
Okay, all right. So Mr. Shimel, because there's nothing in dispute, I can set this for a final hearing to finalize the divorce. But there is one form that I'm going to need, either you or her. It might be easier for you since you're local, to fill out. It's called a judgment of divorce. That's a form that you can get online.
No.
That's a form that you can find online. I'm sorry, go ahead.
Could I come back in the courthouse and do that? I drive a truck. I am not very computer savvy at all.
Yeah, if he wants to come in, I'll dig through the drawer.
Yeah, I think we do have those forms here at the courthouse that the clerk's office can get for you. You'll just need to fill out that form and then leave that with the clerk. The court will send you a notice of the date and time of that final hearing. It'll be remotely like we're doing today, so you don't have to be here in person. And then there's some testimony that I need to take from you to establish the grounds for divorce, and then we can finalize things on that day, okay?
Okay.
Did you have any questions about that at all?
As of right now, no, I don't.
Okay, so we'll send you notice of the date and time of that final hearing, and we'll finish things up on that date, and you're free to disconnect at this time.
Okay, so I can come back in and see, who did you say to get that paper?
If you stop at the clerk's office here in the courthouse.
Okay, and what is, I guess, the name of the paper I'm wanting?
It's called the judgment of divorce.
Judgment of divorce. Okay.
Correct. Okay.
Okay. All right. Thank you, sir. I'll be right in.
Okay. Thank you.
Thank you. Bye.
Okay, council, we'll go on the record now. This is Gadiva versus Rut-Camp. This is file number 2411707. If I could have both council put your appearances on.
Good afternoon, Judge Elliot Blumberg on behalf of Brooke Gadiva, who's appearing via Zoom from my office.
Good afternoon, Your Honor. Miranda Bailey Quick on behalf of James Rut-Camp.
All right, thank you. We're set today for a status conference in this case. I just looked at the file prior to the hearing. It looks like the parties did attempt mediation. Looks like that was not successful. So in terms of scheduling going forward, Mr. Blumberg, on behalf of plaintiff, what kind of dates do you want to set so that we can get this matter resolved?
Judge, the court should be aware, and I'm sure you're not, there is sort of a companion case running parallel to this in the district court. There are eviction proceedings pending, the hearing on the 13th of this month for the eviction of Miss Alcorn, who is a defendant in this case. So that has some bearing on where we're going with this. There is still discovery to be done. Mr. Rut-Camp still has not filed his initial disclosures in this case. There has been some exchange of, well, actually not an exchange. We have sent out discovery even though the initial disclosures hadn't been filed. We need to take the deposition of Jason Thompson, who was the author of the deed that's at issue in this case. So candidly, we need a bit more time to get the case ready for trial.
All right, Mr. Blumberg, are you anticipating any dispositive motions once discovery is completed?
Yeah, we are. I mean, it's no secret. We believe that the deed that created this tenancy was supposed to be something other than what was drafted. If the court, after the discovery is completed, finds similarly, then that would be a basis for a dispositive motion because there's a counter complaint for partition in this case. Ms. Gadiva brought the initial action. Mr. Rut-Camp filed an answer and then filed a counter complaint for partition. So yeah, there's the possibility of a dispositive motion.
All right, thank you. Ms. Bailey, quick.
I had believed that I filed or sent the initial disclosures, and this is the first that I'm hearing of it. So I'll make sure that if those have not been sent to Mr. Blumberg, that those get sent right away. I am currently downstate right now for a conference, but I'll make sure that those will get sent hopefully by Monday at the latest. But I again believe that those were already sent. Discovery has technically ended in this case. I'm not sure. I know Mr. Blumberg sent a couple different requests for dates, but it was always, I would receive a request on, say, a Monday for a Friday deposition of Mr. Thompson, and more notice is needed than that because those dates were never able to be accomplished. I don't have any issue per se if he still wants to depose Mr. Thompson, but discovery has under the scheduling order concluded. And so I just want to point that out. And as far as I'm aware, I believe Mr. Blumberg is assisting in that district court civil action against Ms. Elkhorn. I'm not sure, quite frankly, as she's a party, Ms. Elkhorn is a party to this action and I believe is on Zoom. Why or how that would impact this case whatsoever, or what bearing it would even have whatsoever on this case. This case certainly has priority, and I don't even frankly know how district court would be able to evict Miss Elkhorn given the current circumstances, but nonetheless, I'll leave that to the parties to figure out at that hearing. Lastly, mediation was unsuccessful. I offered on a couple different occasions that if Mr. Blumberg with his client want to have the property appraised, to have a different appraisal, let me know. I never heard whether or not that was going to happen. We're the only party that has an appraisal at this point. We're ready to proceed forward. This case has been brought and filed over the course of multiple different occasions and times, and there just needs to be some resolution. So I would ask the court to proceed forward. We've attended mediation that was unsuccessful, to proceed forward with getting it on the trial docket.
Judge, could I just briefly respond, or would you rather not hear from me?
No, that's fine. Go ahead.
Again, we have not received the initial disclosures, and by court rule, discovery can't take place until those initial disclosures are filed. That's what the court rule provides. We filed our initial disclosures back in October. Hence, we could engage in discovery. The defendant has never filed the initial discoveries or initial disclosures, or if he has, we never have received them. So to say that discovery is over and we're somehow should be precluded seems a bit disingenuous if those are the facts.
All right, well, I would like to move things along. Mr. Blumberg, in terms of what the discovery you'd like to do going forward, how much time do you think you would need for that?
I would think 60 days.
Okay, so the court's going to order that the discovery is to remain open for 60 days. Either side has 90 days to file and notice for hearing any dispositive motions for summary disposition. The court will set this for a status conference at 90 days. If no motions are filed, then at that time, the court will set it for, I'm assuming this is a bench trial. Has either side demanded a
Yes.
jury? Okay.
Yes, it is.
So the court will set it for a bench trial. If there are motions that are filed, then we'll be able to get those heard. To the extent there are any claims remaining, then we can set those for trial at that time as well. Mr. Blumberg, do you have any objection to that as a scheduling order going forward?
No, I do not. That would be fine.
Ms. Bailey, quick.
No, I guess at this point, I don't know if the court is in a position or able to, my client has had exclusive use of the property and I guess just pending this period of 90 days. If the court would entertain a motion for exclusive use of the property for my client, just so that there's not an issue there. I again believe and I hate to bring it up in this case, but these companion cases that are being filed in other courts, I think are just a form of harassment, frankly, and in a way to delay the inevitable with this case. And if there was an order for exclusive use and possession during this period of time, that might help alleviate some of the other cases that are pending.
Judge, that would be totally inappropriate at this point. The court is aware, maybe, again, I shouldn't presume that you would be aware. My client has a personal protection order against Mr. Rut-Camp. Mr. Rut-Camp's live-in girlfriend, the defendant, Miss Alcorn, has a personal protection order against Brooke Gadiva. If we are successful, and I believe that we will be in the eviction proceeding whereby Ms. Elkhorn is removed from the house, then my client will have access to be able to move back into her home. At that point, Mr. Rut-Camp would have to vacate based on the personal protection order issued by Judge Burmeister. So an ex parte order or an order without a benefit of a hearing would be totally inappropriate at this point.
There's
All right,
also
well,
a PPO, Your Honor, for the
Yeah, I
minor
mean-
child against Miss Elkhorn.
Look, this is a status conference. You both are aware for the court to do anything, it has to be by motion. I can't take any action based on representations of counsel at a status conference. So to the extent that either any of the issues you both just raised could or should be the subject of a motion, then just file the motions. We'll get them heard. The court will make decisions on that and we'll go forward. Parties are free to file those kind of motions at any time that they think it's appropriate. The court is merely setting a cutoff for dispositive motions at 90 days. So they need to be filed and heard no later than that time. But other motions that wouldn't dispose of the case for either side, whether it's the claim or the counterclaim, can be filed at any time. So I'll leave that up to both of you to determine what, if any, motions you want to file. And the court will take those up in due course. In terms of scheduling, we'll proceed as I've indicated. I'll send out a scheduling order that reflects those dates, along with a notice of that next status conference at 90 days. And we'll go from there. That's all I have for today. And thank you. You're both free to disconnect at this time.
Thank you.
Thank you.
90 motions, 63.
That's what I gave Jan the other day.
All right, let's see, if I could have counsel, okay, see Mr. Opalewski, Mr. Carey. All right, so we'll go on the record. This is the Schroeder Family Trust et al. Versus Grayling Charter Township et al. This is file number 2411683. We have a number of defendants here, some of whom, or most of whom are represented by counsel. If I could have the attorneys put your appearances on the record, please.
Good afternoon, Your Honor. Mr. Opalewski, William Carey appearing on behalf of plaintiffs.
Good afternoon. My name is Larry Opalewski, and I represent many of the defendants here. I can list those for the court if that would be helpful.
Yeah, if we want to go ahead and make a record of that, I think that would be a good idea.
All right. Again, I'm here on behalf of Frank M. and Lisa M. Ingalls Trust, Leonard Buck, Shirley Buck, Timothy J. Mauk Trust, Christopher P. Erickson, Natasha L. Erickson, Brandon Q. Martin, Jeffrey S. Smith and Luann M. Smith Trust Number 1, Cheryl D. Zadunik Trust, Sheila K. Fortino, Charles J. Fortino, and Howard A. Becker Revocable Trust.
Okay, thank you. I don't think we have any other attorneys appearing today. We do have some folks, I think, joining who are not represented, who I will address in a moment. But starting with the lawyers and Mr. Carey in particular, I think the last time we met was back in December. We extended some dates and then set today as a status conference. So Mr. Carey, on behalf of the plaintiffs, can you tell me from your standpoint where things are at?
I only have one. I'm from asking for discovery, I'm completely satisfied. I do want to report to the court that I am late in answering discovery provided by Mr. Opalewski. I'm working hard on that. Got us fractional ownerships to deal with, and I thought I would be able to provide at least final unsigned copies to Mr. Opalewski early this week. I've not been able to do that quite yet, but I'm close, and that's what I have to report. I don't recall whether we addressed at earlier hearings whether facilitation was appropriate in a case like this. It's my opinion that it is. But as I say, I'm confident and comfortable with the information I've gathered, and I'm ready either to mediate or to try the case. But I know, in fairness, Mr. Opalewski is waiting on discovery from me.
All right, thank you. Mr. Opalewski?
Yes, that's accurate, Your Honor. And I do appreciate Mr. Carey's comments on that. Yeah, we are waiting for some discovery responses. We may or may not want to schedule a deposition or two after that. But beyond that, Your Honor, it's just a matter, as you know, of kind of putting the case all together and then either facilitating or trying. I tend to agree that this type of case is usually a good candidate for facilitation, but I don't have authority to bind my clients on that here today. So I would need to discuss with them first.
All right. Outside of mediation, Mr. Carey, are you anticipating any dispositive motions?
No.
Okay, Mr. Opalewski?
I'm going to need to see the results of the discovery first, but my inclination is likely not.
Okay. And Mr. Carey, if the court were to order mediation in this case, what do you think an appropriate time frame is?
April.
Mr. Opalewski?
Yeah, again, depending on, what the discovery shows and if we can get a dep or two in if we need it, then, I don't have any issue with, April or May, somewhere in that range.
All right, okay. Anybody who is not represented by Mr. Opaleski, that's connected, do any of you have any comments regarding mediation or anything that we've discussed?
I don't. This is Luke Noss.
I do not.
Okay, and sir, the one who just spoke, sir, can you tell me your name, please?
Mark Noss.
Mr. Noss, okay. All right. Okay, so for purposes of today's scheduling order, the court is going to order that mediation occur within the next 90 days. The court will leave discovery open to the extent that the parties, Mr. Opaleski needs to take any depositions during that time. But the court will order that as a firm deadline for mediation. The court will set this for a status conference at that 90-day mark. If the case has not settled, then the court will set trial dates. I'm assuming this would be a case to be tried before the bench. Mr. Carey, is that correct?
Yes, sir, that is correct.
Mr. Opaleski?
That's my understanding as well, Your Honor.
Okay. So the court will then set it for a bench trial if the case did not settle through mediation. I will put those dates into a scheduling order that'll go out to the attorneys and to the unrepresented parties. Mr. Carey, anything further that we need to address today from your side?
No, sir. Thank you.
Mr. Opaleski?
No, my only issue was the discovery, and we've covered that, so I think we're all set, Your Honor.
Okay. All right. Thank you. That's all for this hearing today, and all parties on this case are free to disconnect at this time.
Thank you all.
Thank you.
The person that's connected on Christopher's iPhone, can you tell me your name, please?
Yes, this is Christopher Erickson, and Natasha Erickson is listening as well, but not directly in front.
I don't see you on my docket. Are you sure you're connected to the correct courtroom?
Yeah, we're in the group with the Tim Malk and the McBride, it's not McBride, it's under something else, but our lawyer is Larry Opaleski.
Gotcha.
And William Carey is.
Yep. That hearing was at 2:30, so we've already had that hearing.
I apologize. I thought I was signed in right at 2:30, but maybe it was a little after. So I will catch the cliff notes.
Okay, sounds good. Thank you.
Yep, no problem. Bye-bye.
All right. We'll go on the record then in Hollister versus Hollister. And this is file number 2411759. If I could have both counsel put your appearances on, please.
Juanita Massey appearing on behalf of Brent Hollister, the plaintiff, who's seated to my right.
And good afternoon, Your Honor. Attorney Kelly Thompson on behalf of Leslie Hollister. I just spoke to her a few minutes before this hearing. I think she was planning to sign on. If you don't have her in your waiting room, then you can try and give her another call.
Looks like she just popped in, so I'm connecting her right now.
Thank you.
Okay, looks like she's connected. So we're on the record here today for purposes of pretrial conference. On behalf of the plaintiff, Ms. Massey, can you kind of tell me the status of this case and what you would like to see for scheduling going forward to get things resolved?
Still need some discovery, Your Honor, and their spousal support still at issue. Some personal property and debt that needs to be discussed. I know that we have agreed and there's an order for mediation already. So we're just waiting for CRC to reach out to us to get mediation done. So I would ask for maybe 60 to 90 days for more discovery and get mediation performed.
Okay. All right. Ms. Thompson?
I would agree with that, Your Honor. I would still like to address the issue of spousal support, interim spousal support today.
Okay. All right. So just in terms of scheduling then, the court, it sounds like we've already ordered mediation, but the court will just reiterate that in its scheduling order. The discoveries to remain open for the next 90 days and mediation to occur within that time. And then the court would set this for another status conference at about 90 days. If the parties are able to reach an agreement through mediation, we can use that time to take proofs and enter judgment. And if not, then we can discuss further scheduling and setting it for trial at that point if necessary. In terms of spousal support, Ms. Thompson, that's a request from your side?
Yes, Your Honor.
Okay, what would you like to say in that regard today?
Your Honor, this is a 40-year marriage. My client has not worked during the marriage. She primarily helped raise the children. She's relied entirely on Mr. Hollister's income. Ms. Hollister is currently unable to work, not only due to her time out of the workforce, but also her age, and she's fighting cancer. She's currently at risk of losing her home. She's without heat. I understand that Mr. Hollister was paying that bill and he's let it lapse and shut off. Her hot water line has broke. I think the case law supports that a woman of Ms. Hollister's age can't be expected to develop a viable career at this stage, having been out of the workforce for so long, in addition to her health concerns. I would cite the court to Demon v. Demon, the McLean case, as well as the Wiley case. I can give some citations if the court is interested. On the flip side, Mr. Hollister is, as I understand from the plaintiff's answer to our motion, he's getting $18.49 a month in Social Security, in addition to some food stamps. He worked during the marriage, making around $75,000 a year. He quit his job or retired voluntarily during the divorce process, once he filed for divorce, and I would argue in contemplation of divorce. I would anticipate that once the divorce is finalized, he'll return to work. I understand that he's also supporting his girlfriend, who he moved in with under the Social Security benefits that he's receiving. So given that we've agreed to attend mediation at this point, Your Honor, I think it's appropriate for an interim spousal support order to be entered for half of his Social Security, which would be $924.50 per month. And that would be my request today.
All right, Ms. Massey.
Your Honor, my client did not voluntarily retire. He has some medical conditions. He's got stage 3 kidney disease, coronary artery disease, COPD and emphysema, severe sleep apnea. And based off his doctor's advice, he was told he can't work anymore. And he had plenty of time in his service there. So he was basically forced to retire. It just unfortunately happened about the same time he filed the divorce, but he's got medical records that show that he cannot work anymore in the job he was doing. He's getting about $1,849 per month in Social Security. He's barely making it himself. He has very minimum in food assistance. How much is your food assistance? Like $20? $23. At this time, he's barely making it himself. The defendant is, from what my client's been told, has gone through cancer treatments and is no longer having any more cancer treatments, and is younger. She's 58. She could get a part-time job or a full-time job and make just about as much as he's making on Social Security. So we're asking that the motion be denied at this time until we get more discovery on medical records and things of that nature. I do have interrogatories that have been sent out requesting medical records for the defendant to figure out what's going on medically for her and if she's able to work.
All right, well, I mean, okay, I guess I'm gonna need to take some testimony today, because the court, you know, I can't just make this decision based on the arguments of counsel unless we have some kind of agreement. So I need to have some testimony in the record as to what each side's current income is, and so forth. I don't think did either of you submit any kind of documentation with regard to this motion?
I did not, Your Honor.
I didn't submit any form of verification, Your Honor. That was before we had agreed to attend mediation, but no, we didn't submit anything in addition to our motion.
All right, Ms. Thompson, are you prepared to take some testimony of your client here today? Because again, I don't think I can just, award spousal support on the basis of argument.
I am prepared for that, Your Honor. I appreciate the court taking the time to do this today.
All right, so Ms. Hollister, I'm going to ask that you unmute, please.
Okay. Is that better, sir?
Yep, are you able to hear me?
Yes, sir, I am.
Okay, can you raise your right hand, please?
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Ms. Thompson, go ahead.
Thank you. Ms. Hollister, how long were you and Mr. Hollister married?
We've been married about 38 years now.
And when was the last time you've held steady employment?
Oh, wow. Over 20 years ago.
Okay. Did the two of you share children while you were married?
Yes, ma'am.
And are any of them still minors?
No, they're both adults nearing 40.
So during your marriage, would you say that you helped raise the children instead of working?
Help, yes.
Okay. And have you been diagnosed with anything health-wise in the last several years?
I was in the, I've had cancer, which I've been cleared of, recently. I have COPD, I have asthma,
Okay.
severe major depression.
Are you currently able to work?
I don't believe so, no.
Okay.
I can't go outside when it's this cold out because I can't breathe these temperatures. It triggers very severe asthma attacks. And I don't drive, so I would have to walk.
Okay. And during your marriage, given that you were staying home, providing for the children, were you relying on Mr. Hollister's income?
Yes, ma'am.
Okay. Where do you live currently?
I live in Almont, the village of Almont, Michigan, 508 Edinburgh Lane.
And was that the home that you and Mr. Hollister shared while you were married?
For the most part, yes. For the
Okay.
majority of our marriage, yeah.
And are you able to maintain the bills in that home right now?
No, ma'am.
And is your heat currently working?
My furnace is broken. We're waiting to see if a part's available. It's like a 40-year-old furnace.
Okay. Do you have any form of income at all right now?
No, ma'am. Just what my friends and family club together and send me for bill paying and such.
Okay. Your Honor, I don't have any further questions.
Thank you. Ms. Massey, any cross exam?
Yes, thank you. You stated you helped raise the children. Did Mr. Hollister also help raise the children even though he was working?
Well, yes, of course.
And you said you're cleared of your cancer now, correct?
Yes, I was cleared in October. I could be wrong about that, but it was around that time.
Okay. And do you have a house payment you have to pay?
No, I have rent every month. I live in a mobile home park.
And how much is rent?
Rent is $777 a month if it's on time. If it's late, it's $827.
And how much is your utilities there?
Right now, from what I'm told, Mr. Hollister and I have no contact with each other. So our son intervenes. And he said 2 weeks ago that the electric bill was up to about $200.
Was that just for 1 month amount or was it a late payment?
I'm not sure. I'm not sure. The gas bill is on one of those payment plans where it's just a flat rate every month.
How much is that?
$87. And now we have to pay water separately. It used to be included in the rent, but now it's separately.
How much is the water going to be?
I don't know.
Anybody else living with you at the moment?
No, I'm here by myself with my small dog.
Okay. Your son was living with you though, correct?
Yes, ma'am. He moved out last weekend.
Have you attempted to try to get a job?
No, I can't leave the house. When it's this cold out, I can't breathe the air.
I have no further questions of this witness.
All right, thank you. Ms. Massey, did you want to take any testimony from your client today?
Yes, Your Honor, thank you.
All right, Mr. Hollister, if you can raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand, and Ms. Massey, please proceed.
Thank you. Mr. Hollister, can you tell the court the reason why you are now on Social Security?
I retired due to health reasons back last June. My doctor took me out of work due to my breathing. When I was driving to work one morning, I had such a hard time breathing. I was about passing out while I was driving. I was diagnosed with over the period of several months of testing. I was diagnosed with COPD, severe asthma, and I've known all along that I've had sleep apnea, but from what I understand, it's gotten a lot worse now. Pardon me, I'm nervous about all of this. I also suffer from anxiety.
And do you also have coronary artery disease?
Yes, they also diagnosed with coronary artery disease.
And then what about kidney disease?
Yeah, stage 3 kidney disease.
And are you being treated for that still?
Yes,
Okay. And so that actually caused your retirement, correct?
correct.
Okay. And how much do you receive in retirement?
Just got a raise, so it went from 649 to 1849 to 1895 a month.
Okay, so it's a little bit higher than originally stated by
Correct.
the council. Okay.
Correct.
And did you receive any, when you were put off work, did you receive any short-term disability or any insurance payments?
I received 1 month or one period of short-term disability. After that, they took me off of short-term disability. They said that my medical records at that time didn't show that I qualified for short-term disability, even though my doctor said that I wasn't fit to work. So he kept me out of work. I was on doctor's notes up through November 4th or 5th. So I had no money, no income from July up until I retired October 4th. I filed for Social Security just before I retired. I want to say September 30th. I filed for divorce on September 25th with the last money that I had, because I had to get this divorce proceedings going before I didn't have any money to do it. Because at the time,
That's fine. You don't have to keep going. I got
okay.
the answer.
Okay.
And then was there an insurance check that went out? Any type of?
Yes. Yes, my wife, after she had the surgery in October of 2023, where they diagnosed her with cancer, as soon as I called her on the 25th of September of 2024 and told her that I was going ahead and filing, then she went ahead and filed for the catastrophic illness and the hospitalization, of which she received $16,400.
And did you receive any of that money?
No, I didn't.
So when did she receive that money that you know of?
The middle of October and I want to say the middle and the end of October, somewhere around there.
So during the pendency of this case, she should be living off that 16,400 at the moment, correct?
Correct.
Okay. And if you have to pay spousal support, are you gonna be able to afford your bills?
No, because starting the 26th of February, I have to start paying, in addition to what I've been paying all along, I have to start paying 500, I want to say it's like $526 to the student loans.
And how much is your student loans right now?
72,000.
Okay. I have no further questions.
Thank you. Ms. Thompson, any questions for Mr. Hollister?
Yes, just briefly, Your Honor. Mr. Hollister, I want to make sure we're clear. You receive $18.95. Is that in Social Security or retirement?
That's Social Security retirement.
Okay. And how long have you not been paying the utility bills or the rent for the marital home?
I stopped paying that in December of 2023.
Okay. So Ms. Hollister presumably has had to use a large chunk of that 16 for insurance payout to maintain the bills and the rent for the home she's living in. Is that accurate?
No.
How would it be paid?
She didn't receive that money until October of 2024.
Understood.
My son Dagan was living with her, and Dagan was paying the bills at that time.
But you've not been living there or paying the rent or utilities since 2023.
Since December of 2023.
Okay. And who do you live with now?
I live with my girlfriend and her parents.
And do they work?
No,
Are you supporting them as well?
no, no.
How do you guys support yourselves? Or how do they support themselves?
My girlfriend is being supported by her parents because she is taking care of her parents. They're 80 years old, so they are on Social Security. And so they're supporting her. And I'm paying $600 a month in rent in order to live there.
So the other people in the home where you live have some form of income?
Correct.
Okay. Nothing further, Your Honor.
All right, thank you. Okay, generally, first of all, I mean, the court needs to make sure that it's clear for the record. This is merely a temporary spousal support decision during the pendency of the divorce. So this is only to get the parties through until either there's an agreement through mediation or the court makes a final decision on spousal support after or when it divides up all the assets and debts of the marriage. Looking at it from a temporary spousal support standpoint, typically what the court does is it takes the income information from both parties, adds that up, gets a total, divides it in half, and then awards the party with a shortfall the amount to bring them up to half of the income, total income of both parties together. Of course, there's all kinds of factors that the court looks at when making a final decision on spousal support: the health of the parties, the ability of the parties to pay, the length and duration of the marriage, the parties' customs and behavior during the marriage, and so forth, all go into a decision for spousal support and are properly considered even in a temporary award. So first of all, the court recognizes that this is a long-term marriage, that there isn't any dispute that Miss Hollister during the course of the marriage was primarily the homemaker and did not work outside of the home and relied on Mr. Hollister for support and income, at least during the last 20 years of the marriage, which would have been over half of the marriage. And that's a significant factor to the court in terms of the spousal support. Also, the fact that Miss Hollister does not currently work and hasn't worked in 20 years, I don't think it's reasonable to expect that she would immediately be able to go out and earn an income, regardless of health. Without any documentation as to the health situations of either party, I find that to be generally equal. But certainly the length of the marriage and the fact that Miss Hollister was the homemaker and didn't work outside of the home for the majority of the marriage are significant factors. And the fact that she doesn't have any means of income at this point at all. I'm sure Mr. Hollister is not living a lavish lifestyle at this point based on the testimony. However, as difficult as it may be for him to get by on about $1,900 per month, it's certainly equally, if not more difficult for Miss Hollister to get by on nothing per month. So the court finds that an award of temporary spousal support would be appropriate in this case. The court is going to award Miss Hollister support in the amount of $700 per month. So that's just under half of what Mr. Hollister is making. I think that's a reasonable and fair amount that would at least provide for some means for Miss Hollister to support herself during the pendency of this action. That also takes into account that she may have received a lump sum of money that's available to her for support as well. That takes into account further that Mr. Hollister is living with other individuals who presumably are able to contribute to the household as well in terms of bills and so forth, whereas Ms. Hollister is not. So balancing all those factors, again, the court finds that that is an appropriate award. Ms. Thompson I'll ask that you prepare an order reflecting that that's a temporary support. The court is going to order that payment begin. It's February 6th. The court will order that Mr. Hollister submit the first payment on February 14th, and then on the 14th of every month thereafter until further order of the court. So Ms. Thompson, please put that into an order, submit that either with a stipulation as to form from opposing counsel or under the 7-day rule. And we'll go forward from there. The court will put out that scheduling order with the dates that we've discussed here today. That's all I have. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, looks like we got all the parties connected. So we'll go on the record in Colin versus Colin, file number 2411622. We have Mr. Vernon present with his client, Miss Colin. We have Mr. Colin present by video, also Mr. Vernon and his client by video. This is set for a couple different matters here today. We do have this set for a status conference. Mr. Vernon, we've got a motion from you to compel discovery, and then a motion alleging that Mr. Colin has not complied with the prior order of the court. So if we could start first with your motion regarding discovery. I did review your motion. Is there anything you wanted to state for the record in support of that?
All I would add is that discovery still has not been provided. We sent over those requests to produce documents. We've received none. And we obviously would want those documents before we had in any evidentiary hearings. And I know we've rescheduled mediation once, so I certainly would like those documents prior to the mediation.
All right, thank you. Mr. Colin, is there a reason why you haven't provided the documents to Mr. Vernon?
For one, I don't consent. For two, I haven't asked the plaintiff for any type of discovery of her information that they want to disclose up from me. And for three, we are separated, and we were only together for 3 years, and we were on food stamps and government insurance prior to her separation. And I don't have any financial things that even matter to disclose of that would benefit them in any type of way besides my house.
Okay, so it doesn't matter whether you consent or not. If they make a proper request, then you're required to provide that information to them. So that's not a reason. The fact that you haven't requested any information is not a reason. They have a right to request information from you. And your third reason, the status or duration of the marriage also doesn't really have anything to do with discovery. So you haven't stated any legal reason why you shouldn't be required to turn over those documents. So Mr. Vernon, the court will grant your motion to compel. In the order granting the motion, Mr. Vernon should specify that Mr. Colin has 14 days to comply with the order. Mr. Colin, if you fail to comply with the order to compel, then you may be subject to contempt sanctions, including default. So you are required to turn over those documents. Do you have any questions about that?
I don't know what documents he's requiring.
Mr. Vernon, is this the subject of a written request?
Yeah, yes, Your Honor.
Okay, so you've been provided with a written request, Mr. Colin. You just need to read that and provide the documents that have been.
Well, they're going to have to resend them again because they might have got misplaced.
Mr. Vernon, that's up to you whether or not you want to send a courtesy copy to Mr. Colin. If you've already served those on him, Mr. Colin, that's your problem if you lost them. I'll leave that up to Mr. Vernon if you want to send him a courtesy copy or not.
Seems
Thank you. I think we can probably manage that. Your Honor, I would ask the court, in our motion, we did ask the court to consider costs in this matter as Mr. Collins answers and is without substantial justification. Our appearance here today obviously is costing my client time and money. We would ask the court to consider imposing sanctions as a result for fees as a result of having to be here today to compel that discovery.
Because this is the first motion to compel, and because Mr. Colin is a non-attorney and may not have understood his requirements under the court rule, I'm not going to impose any attorney fees at this time. If he further fails to comply, then the court would consider those at a later date.
Thank you.
The request for the appraisal has already been done as well. I did get that to go through.
Okay, so that's the next question. As Mr. Vernon, your motion to show cause does relate to that appraisal. Mr. Colin, you're saying that an appraisal has been done, is that correct?
Yes, Your Honor.
Okay, Mr. Vernon?
So, Your Honor, we did receive a copy of that appraisal today or yesterday late. The the motion that we filed, I think still has some bearing and some validity. I think it's pretty clear that Mr. Colin, prior to the filing of our motion, intentionally interfered with the accomplishment of that and essentially caused additional delays. The appraisal is done now, except that Mr. Colin is refusing to share in the expense of that appraisal. The cost is $500, so I would ask the court to order Mr. Colin to pay to my office $250 so that we can pay Mr. Kirsten the amount owed to him.
All right, Mr. Colin, is there any reason why you shouldn't pay half of the appraisal cost here?
Well, for one, once again, I don't consent to any of it, so you guys are going against my wishes. If she wants the appraisal, that's not my fault if she doesn't have the money to do it. I did go forward with making it happen for them, like it was stated it was supposed to do. Nothing was stated that I was supposed to supply any financial support for the situation. And as of the year so far, I've already supplied $6,564 of support to go towards her affair and her attorney, and I guarantee that it hasn't gone towards my children. So
okay. Again, it doesn't require your consent. The law requires that appraisals be done when property has to be split. So it's not something that you have to agree to in order for it to happen. It is pretty standard practice for the parties to split the cost of appraisals. So the court will order that you split the cost of that. And Mr. Vernon will grant your motion to that extent.
How does the law apply when the oath of the marriage has been broken? How does the law still apply in accordance to what makes the law? When you get married, you have to say an oath, which makes the law. How do you not get penalized when there is clearly an affair and negligence going on in a marriage towards one party or the other? How does the law still apply when the oath that makes the law is being tampered with and not followed?
Okay, so Mr. Colin, Michigan is a no-fault divorce state. That means that parties can get divorced without having to prove that the other side was at fault. It also means that although fault can be a factor in how assets are divided, generally assets are divided equally. So that's the law.
It's a sad law for our state, Your Honor.
Well, you can contact your legislator and ask for them to see to change that, but that is the state of the law at this time. So the court will order that you pay half of the appraisal. And Mr. Vernon, if you can put that in your order, I will provide for 30 days for Mr. Colin to remit that payment to your office.
Payment to our office, okay.
And can you provide to him, if it wasn't part of the appraisal, an invoice from the appraiser with the exact amount?
Yep, I have all of that right here, and we will, if we haven't already sent that out, we will get that sent out.
Okay. In terms of proceeding, Mr. Vernon, I'm not sure where things are at in terms of scheduling. Can you tell me what the plaintiff is requesting for scheduling going forward?
So my recollection is that at the last hearing, the court granted our motion to extend the deadline to accomplish mediation because there was evidence and discovery that we had not received. I believe at that time the court ordered that the further hearings were going to be essentially scheduled after mediation. So I don't know that we have any further dates. We're still working on getting a date for mediation. We obviously want the discovery first. So if we can get all of that stuff and then schedule a date for mediation, you know, I mean, if we've given him 14 days to comply with the discovery, I think we would need at least 14 days beyond that to accomplish mediation. So if we could have a status conference, that's 30 days. So somewhere in the 45 to 60 days out, I think we would have made some progress that we can then report to the court.
All right, thank you. Mr. Colin, is there any scheduling that you would like to request in this case?
No, Your Honor.
Okay, so the court will order that mediation is to occur within the next 60 days. The court will set this for another status conference at that 60-day mark. If the parties have been able to reach an agreement through mediation, then we can use that date to take proofs.
I did forget about one thing, Your
Sure.
Honor.
Go ahead.
I filed a complaint about parenting time that the plaintiff had missed. And I received a letter back from the plaintiff and her attorney, but there was nothing showing that we were how we could go forward with me getting my 2 hours back that I missed.
Did you file that complaint with the friend of the court office?
Yeah.
Okay, so they should schedule a hearing for you before the referee on your complaint.
Okay, they did not do that yet, and I received their supposed evidence that Doug Mago and I agreed supposedly, but it has nothing to do with me and Doug Mago. It has to do between the courts and me and the plaintiff. So that is not factual evidence submitted.
All right, I'm just checking. We're going to check right now to see if that hearing's been scheduled yet.
Your Honor, I have it on my calendar for next Wednesday at 9 a.m.
That's for you, Mr. Mertz.
The 12th is the hearing with you. Half day duration as defendant's objection to referee recommendation.
That's a separate one.
I do not. So sometimes those, I mean, if it's filed in front of the court, I don't know if they've done anything with it or not, but I do not have it.
When did you file that complaint, Mr. Colin?
That complaint would have been filed January 9th. Yes, the 9th.
All right. After this hearing, I'm going to check with the friend of the court to see why that hasn't been set for hearing. It should have been set for hearing.
Okay,
now,
thank you.
I think.
Your Honor,
Next Wednesday, our hearing is on the objection to the referee's recommended order. So that's a different matter.
Yes. Yep.
Your Honor,
Hold on one second. I'm just going to put everybody on hold for a minute and check with friend of the court right now to see if I can find out where your complaint is, Mr. Colin. Okay.
Okay.
I'm just going to put both of you into the waiting room for just a minute.
Thank you.
Okay, we're back on the record. I did just check with your case manager. They have the complaint and answer filed. They are going to be getting a date within the next couple of days, and the notice of that hearing will go out. So Mr. Colin, look for that in the mail, but they will be scheduling a hearing on your complaint here in the next couple of days.
Thank you, Your Honor.
That'll go forward with the referee.
Okay.
Okay, that's all I have for this hearing today. All parties in this case are free to disconnect at this time.
Your Honor, I had one question, just administratively, because there were two separate motions. Do you want two separate orders, or do you want one order addressing both issues?
I think you can put it in the same document. I think that would be fine.
Thank you.
All right, thank you.
Thank you, Your Honor.
Okay, is this Mr. LaForge that's connected? Hello, whoever's connected by phone, the last 4 digits of 9503. Can you tell me your name?
Barry LaForge.
Okay, thank you. All right, we're on the record in LaForge versus LaForge, case number 046568. The record should reflect that Mr. LaForge is connected. Mr. LaForge, unfortunate, sounds like we had an unfortunate series of events here with regard to your motion. Your attorney, Mr. Leonardson, recently passed away. So I understand that you're trying to get this wrapped up on your own today. Is that correct?
That's correct.
Okay, and I did receive the motion that Mr. Leonardson filed on your behalf. And the motion indicates that there was a judgment of divorce between you and your former wife, who's now deceased. Is that correct?
That's correct.
And in that judgment of divorce, it appears that there was a problem with the description of the property, and you're trying to now sell that, and there's an issue with the title company. Is that what's happening?
That's correct.
Okay. So I reviewed your file. I reviewed the motion. I think you're entitled to have that case reopened and for the legal descriptions to be corrected. So I do find that you're entitled to that relief, and I will grant your motion. I think the issue that you're going to have going forward is you're going to have to prepare an order correcting those legal descriptions. And I think that's going to mean you may need to hire a new attorney to help you with that. Obviously, Mr. Leonardson can't, unfortunately. And I don't know if that's something that, that you have the legal knowledge to be able to do on your own. But I will grant you, I will grant your motion if you can find someone to prepare an order for you.
Okay. How do I just go, like, could I use Bill Carey or somebody here in town and tell them what's going on, and then they could take it over? Or?
Yes. Yep. I think that would be a reasonable way to go. And you can show them the motion that Mr. Leonardson filed, indicate to them that today on the record, the court granted your motion, but you just need help with the preparation of the order.
Okay. All right. I'll go over there right now.
Yeah, and they don't need to schedule another hearing because I'm granting the motion on the record today. They just need to submit the order to the court to be signed.
Okay. Now, is someone going to give me that piece of paper before I leave the courtroom today, or will they get that?
Yeah, Miss Medler, our clerk, will get you a copy of whatever you need to take over there today.
Okay, great.
All right. Do you have any questions at all?
Nope. I'll just get that done, and hopefully they're still open today, and I'll get in there and get this rolling. I appreciate it.
Okay. Thank you. You're free to disconnect at this time.
Okay. Thanks. Bye.
Good afternoon, Your Honor.
Okay, good afternoon. We're on the record now in Walker versus Munson. This is file number 2311516. If I could have counsel put your appearances on, please.
Good afternoon, Your Honor. Rebecca Filietro appearing on behalf of the plaintiff, Tiffany Walker.
Nick Rizzo here on behalf of defendant Munson Healthcare Grayling, Your Honor.
All right, so this matter was set for a final status conference today. The last time we spoke was back in October. We have some trial dates set for March, so in about a month. Ms. Filietro, on behalf of plaintiff, are we going to be proceeding to trial in this case?
I spoke to Mr. Rizzo this morning, Your Honor, and again this afternoon. We're trying to resolve the case. I think we're still a little bit far apart, but there's definitely been some efforts made in that regard.
All right, Mr. Rizzo.
I'll concur with plaintiff's counsel, Your Honor. It's my understanding, my office earlier this week called the court, and we wanted to try to ascertain whether that was a firm trial date or not. It's my understanding that that trial date is it. We've got that date. No one else has that date, perhaps. And if the case doesn't settle between now and then, we'll be up there on March. I think it's March 10th, Your Honor, Monday, March 10th.
Right.
Prepared to try the case.
Yeah. All right. I think what I'm going to do in light of what you both indicated here today is set this for one more status conference just prior to that trial date to give the parties one more opportunity to see if we can get this resolved before I call in a jury and we go down that road. It is a firm trial date. I don't have any other trial scheduled, so if it doesn't settle, the court would intend to proceed with trial as currently scheduled. But I think it would be reasonable to just set this for one more status conference prior to that. So, Tyler, do you have any objection to that?
I don't, Your Honor.
I have no objection, Your Honor.
Okay. All right. We'll send out notice of the date and time of that final conference. And that is all I have for today. And you're both free to disconnect. Thank you.
Thank you, Your Honor.
All right. Do you have anything else?
I do not.
All right. That concludes the court's